Right. So, very good morning to our members joining us today on cross-border data flows and data protection, our third webinar on digital economy issues. As businesses tap on opportunities in e-commerce and the digital economy, the ability to move data across borders, be it consumer information, business intelligence, internal records, become important. Some have called data the new oil, and if so, and if indeed powers the digital economy, then securing the supply of flow of data would be essential. But this movement of data is not immune to regulatory compliance and barriers. Data localization laws exist in some jurisdictions, privacy protection laws, national and cybersecurity regulations, and even protectionist measures are also being passed. Many businesses have also raised the disparate regulatory regimes that are developing in different jurisdictions, making compliance potentially both complex and costly. We are very pleased to have with us today speakers from both government agencies and experts from the private sector to share with us how businesses can overcome these barriers and be a first mover in taking advantage of the digital economy. We have Evelyn Goh, Director at Personal Data Protection Commission, Dominic Ng from the Infocomm Media Development Authority, Alvin Toh, Chief Marketing Officer of Straits Interactive, and Lyn Boxall, who runs a law firm specializing in data protection and cybersecurity. I will let them introduce themselves better during their own presentations, but a very big thank you to all our speakers for joining us today and sharing your knowledge with us. Before we start, I would like to highlight that the Q&A segment will follow the presentations. There are two ways you can pose your question. Firstly, you can type them in while the presentations are ongoing through the Q&A function below. For these questions, I will consolidate them and post them on your behalf to the presenters. Alternatively, you can post your questions directly to the speakers. You can do so during the Q&A segment by using the raise your hand function. I will let you know when it is your turn so that you can unmute yourself, introduce your name, your company or industry, and post your question to any of the speakers. And now, without further ado, I will hand over the time to Evelyn.
Thank you, Jason. I'll just get the slides on. Right, a very good afternoon to everyone, and thank you for taking time to attend this webinar. We've been all very familiar with data as an enabler of growth for the digital economy. You probably heard this many times, that digital economy presents opportunity across sectors, and Singapore, of course, have to keep pace and not lose our competitive advantage. So one key aspect of the digital economy is data flows. So data flows have been increasing many times over the last decade. And of course, is projected to increase even more in the next few years as digital flows of commerce, information, video, communication, or intra-company traffic continue to surge. I think you would agree with me that during the current COVID-19 situation, this is even more so with businesses moving digital, more employees telecommuting from homes, conversion of physical conferences, workshops to virtual ones, and so on. So data flows basically supports business operations, so your delivery, logistics, e-commerce, also corporate functions, sort of consolidation of HR functions from different regions or countries, and product development, including training of AI engines. So, however, the increase in adoption of digital technologies and the sharing of data across borders are not without challenges. So over the last few years, we see diverse rules governing cross-border data flows. There are laws that prohibit transfer of data outside of countries. There are laws that require perhaps a set of conditions to be met or prior approval by, for example, regulators before the data can be transferred out of the country. And there are also laws that applies to a wide range of data, even beyond just personal data. So interestingly, this morning I also read, I I saw a post on sort of the latest stats or consolidation of a number of countries with comprehensive data protection regulations. And the stats was as updated as 21st of July. There are currently 121 countries with comprehensive data protection laws. That is about 63% of countries, and about 83 data protection authorities around the world. I think we can only see that these numbers will continue to increase. So many of these data protection regulations have requirements on transfer of data out of the country. And while the data protection laws differ from country to countries, there is attempt at regional level to bring some convergence to these disparate laws through regional efforts. So of course you have EU with GDPR, and there are other efforts in APEC and ASEAN. So in APEC, which we will have a more detailed presentation on APEC CBPR, which is a cross-border privacy rules system later on. But this map basically shows that there are currently 9 APEC economies on board this system to facilitate data flows between APEC economies, and of which Singapore is one of the economy on board the system. We also have some efforts at ASEAN to facilitate intra-ASEAN data flows and to work towards a more harmonized digital data governance framework in ASEAN. You notice on the map there are some countries listed as considering or looking at localization of data or restricting some types of data flows. And these are usually for a few reasons. Such as for national security, to protect personal data of their citizens, economic protection, and for ensuring quick access to data by their law enforcement agencies. Data localization requirements actually is quite a wide range from countries requiring a copy of the data to be kept in the country, but data can still be transferred out. Or an assessment or approval required by the regulators before the data is transferred out, or where certain data must be processed and stored locally. So this is where full localization of certain types of data happens. So against all these, what we aim to do in Singapore is to build bridges between Singapore and other economies. We want to help businesses assess markets, participate in regional efforts to stay connected, to ensure global connections, and for data to flow freely and securely. So we have been active on, at free trade negotiations, at WTO. We have DEAs and FTAs. Some of you might have attended earlier talks on this. So we have the CPTPP, the DPA, which is between Singapore, Chile, and New Zealand, Singapore, Australia. These are the more recent ones, and we're also embarking on talks with Korea. So on a multilateral platform basis or regional cooperation, we are participant of the APEC cross-border privacy rules, and we're also working with the other ASEAN member states to develop what we call the ASEAN certification for cross-border data flows, as well as model contractual clauses. These are basically to help facilitate data flows in ASEAN. And ultimately, of course, with all these different initiatives, we hope to see interoperability between regional efforts. So on a bilateral basis, we have the MOUs. We have MOUs with a number of countries such as Australia, Philippines, Hong Kong, and UK. We're also open to bilateral cooperation through a number of ways. We want to explore mutual recognition of data protection regime. We also like to have our data protection trust mark recognized or mutual recognition with countries that have a similar trust mark. And lastly, to also explore regulatory sandbox, looking at specific use cases, test out the idea, and facilitate data flow with other countries. So I mentioned about corporations and what's going on within ASEAN. Some of you may not have seen this, so I thought I'll take a minute to show you this on the ASEAN Framework on Digital Data Governance. This was endorsed by the ministers in 2018. So there are basically 4 key areas of work under this framework. Firstly is the harmonization of data management in Singapore in this initiative called ASEAN Data Management Framework. And then we have the cross-border data flow mechanism. So this is a dual approach where there is a certification and a model contractor clause. And third, we have the ASEAN Innovation Forum. Basically, this is a multi-stakeholder sharing and discussion. And lastly, we've set up what we call an ASEAN Data Protection and Privacy Forum. So basically, this is a platform for data protection regulators and policymakers in the region, in ASEAN, to share best practices, harmonize legal framework, and of course, enforcement cooperation. So this very quickly ends my presentation. Thank you.
Alvin, right, thank you, Evelyn. Alvin, it's Alvin, I think you're
now. Okay, good afternoon, everybody. The slides all clear? All right, good. So I'm going to be, there's 2 parts here. I'll be covering a part on the regional trade protection, especially from an operational perspective. And then I'll have my partner, Lyn, a data protection specialist lawyer, who will talk about the impact of GDPR and regional frameworks as well. Okay, and then after that, I'll come back and talk about in terms of what Singapore companies can do. I think from an operational perspective, we have 2 esteemed colleagues from our regulators here who can answer the regulatory impact here. Okay, so if you look at the developments that have driven privacy principles and laws, a lot of them were driven by these technologies, either in tracking, profiling, right, or data analytics. So if you're doing any of these World Wide Web, the social media, you're doing any sort of profiling, especially now we're doing e-commerce. In the last 5 years, these were the rules that have come up, right, to really look at privacy, especially privacy intrusion or use of personal data, right? APEC GDPR, which later on Dom will talk about it. You had GDPR, which is the one from EU, and it has very big impact for us in the region here. For the countries outside of the EU, but European countries, they have Convention 108. When I was in Africa, a number of countries are adopting that. And then for those of you who are actually having a lot of e-commerce platform, may be very familiar with ISO 27000, and they too have introduced extensions in privacy. So these are frameworks and rules that are governing privacy around the world, okay, and something for us to take note of if you are going to venture outside Singapore. Now, looking just around our region, right? Evelyn just mentioned 121 countries have already comprehensive law. If you just look at within our ASEAN countries, things to look out for would be Thailand and Indonesia, right? Thailand has moved or postponed their enactment to next year, and Indonesia supposedly end of this year. The interesting thing to note is that later Lyn will cover these new laws that are coming up actually are heavily based off the GDPR standards, right? So it behooves you to understand what's the implication, especially as a company going out, and what is it that you need to do, and why GDPR is actually an important consideration for you as well. Okay, China of course is also coming up, and that's something to watch out for, and India as well. Okay, so Malaysia and Singapore have amendments. I think we're going to have another webinar covering all the new things that are coming up. In Malaysia, we sit on the advisory committee looking at the next revision for the Malaysian PDPA. And again, they have leanings towards GDPR into some of the new recommendation as well. Okay, so a lot of it is driven through how do they engender trust between countries. Now, a lot of these rely on how are you systematic in your compliance. Now, as a company, we drive these 5 pillars, and these probably 5 values you may want to take on as a company going regional. How do you have ongoing value as a compliance officer to your company, i.e. keeping up with the different rules, right? And for us, we make sure that, when we work with companies here, they're able to keep up and have a framework that's valuable to the company, whether in one jurisdiction or multiple. How is it easily operational and on-demand tracking? I think Dom can speak to that, and that's very much a feature of Trustmark and also accountability. And then collaborative compliance. It's not a one-man job, right? A lot of times you can see the investigations or the audits come down to look at the HODs and the operating units. And do you have multiple dashboards to track? And now, especially later, we talk about cross-border. How do you have a framework, right, to have dashboards that make sense to compare, contrast? Okay, so as a company, we look at operational compliance and we train people in international certifications for privacy. And with that, we are blessed to have also officers from the regional regulators in various countries, and we support regulators in some of the research that we do as well. Okay. Now, I talk about frameworks. So these 2 donuts, as it were, might be interesting for you to take as a handle to understand. The first one is the what we call the information lifecycle, CUDS. In short, those 4 letters, if you write it down, represents the 4 activities any data protection law will cover. If you do any of these 4 activities, you are subjected to the data protection law if it exists in that country. So if you collect, use, disclose, or store personal data, you are subjected to the respective data protection regulation, right? On the right side, I'll cover afterwards in terms of what do you do in terms of a privacy operation. Again, there are also 4 phases in that, and that's based off international best practice, right? So let's look at what is this information lifecycle. So let me break it down. What would subject you to the data protection rules? In collection, the collection points, use of data after collection, processing, right? In fact, now under the COVID thing, many companies have collected inordinate amount of personal data, right? Because of the COVID, right? And then you have retention of data. You have the right to access. Again, is actually pertinent in all the data protection rules. Transfer outside the country, we're talking about today, and disclosure outside organization, whether in country or outside, right? So if you look, these are the considerations. If you do any of these activities, subject you to the data protection rules. Okay, let me break it down some more. Examples. Okay, collection points could be agents if you have on a phone or a call center. You have forms on if you're doing e-commerce, online submission, mobile apps, for example, will subject you to that as well. Okay, the others that if you're looking at usage, okay, these are the consideration, right? We call the 3C, 3I, right? Consent, comply with legal obligation, contract or performance, vital interest, public interest, legitimate interest, right? This is actually based off also the principles of GDPR. It's under this 3C, 3Is that you actually can operate those data, okay? And in terms of storage or disposal, oops, okay, you actually have, my slide's running, okay? In terms of home office right now, a lot of you are working from home, network, cloud storage. In terms of the cloud, there's already a standard even governing cloud storage providers, right? Under the ISO 27, I'll talk about later. I think Dom can talk to it about the PRP side. And what we are seeing right now is that in disclosure, many people are out doing outsourced service. The Zoom is actually an outsourced service, right? Authorities, partners, call centers, even printing companies, right, are subjected to that, whoever you're using. So if you look at these 4 activities and the parties you're dealing with, they're all subjected as part of your value chain to the data protection rules. Okay. Let me go down. Okay. Oh. My slide keep running. Okay. So let's look at the data protection principles. Yeah. These are the common principles that apply, and I'm going to have Lyn come forward and give a bit more color to this, right? But these are the data protection principles that are common, and some of them are named differently, but they apply across the 4 activities that you do, whether you collect, use, disclose, or store, right? And something that many companies, if you want to do a compare and contrast across the different jurisdictions, this would be a framework you would use, right? We have put in some of them here, and that's how we have consulted for companies that want to do one implementation, but have dashboards that make sense for compare and contrast across their different jurisdictional companies that are subjected to the various laws. Okay, so I'm gonna have Lyn talk about what is this impact of GDPR, right? And when does a Singapore company get impacted, and the regional laws and framework. Lyn?
Okay, thank you, Alvin. That was a good introduction for everybody into making data protection make sense. Look at it through CUDS. I'm going to talk about the GDPR. I'm going to talk a little bit about some of the regional initiatives that Evelyn mentioned as well. But always in our work, in our operational work, in actually applying these laws, we come back to that CUDS and the APSR that Alvin will get back to later. So here we are, we go back to October 2018, and this was the announcement by Singapore of signing a free trade agreement with the EU. Now, I imagine that most people on this call are much more aware of the value and benefits of the free trade agreement than I am. But I mean, this was a really big deal at the time. I think Singapore was the first of the ASEAN countries and one of the first Asian countries to sign a free trade agreement with the EU. What's the benefit of a free trade agreement? Well, I think the big highlight benefit was an 84% reduction in taxes and tariffs, making Singapore products much more affordable in Europe, and also coming the other way. So the trade between Singapore and EU goes in both directions. So we set up some rules to make trade more easy. Meanwhile, you'll say, oh my goodness, I've heard about the GDPR. It's this really awful, awful, awful thing. Actually, it's not. It's not so bad after all. One of the things that we get starting back 40 years ago now, when data protection started to be a big thing, when technology started to be a big thing, was a OECD guidelines on data protection. And we'll see that the GDPR covers many of the same elements that were in OECD. So does Singapore. So does Malaysia, Philippines, China, Indonesia. So we do see this convergence that Alvin mentioned before. What we see as well is just, you know, some differences as well. So when we're doing our work helping companies implement these laws, we look at the CUDS and then we look at the differences and how we can take them into account. So the thing that we notice focuses under the GDPR is appointment of DPO. Well, we already have that in Singapore, as people operating here would know. We do data protection. We have a requirement for data protection impact assessments under the GDPR. But gee, the PDPC pretty much encourages that anyway. Records of processing to know what we're doing. Data protection by design, which is designing your system in such a way as data protection is part of it rather than something that's added on later. And the GDPR has a 72-hour notification period for data breaches, which is something that we're going to see in Singapore as well when some amendments to the law go through. Now, if we go back a couple of years, if I think about the months leading up to, or the weeks leading up to May 2018 when the GDPR came in, this was a letter that I mocked up. The source of it was the in-house counsel at a company in India that makes fiber optic cables, and it was a letter, I think, from IBM. So we're not talking personal data, right? It's fibre optic cables is not something we can go and buy at the local 7-Eleven. But you can see what they were saying. IBM or whoever this was, there was lots of these letters. They were trying to clean up their vendor chain because they're going to be liable for vendor acts and inactions under the GDPR. So basically they say here, you know what, by 25th of May 2018, you have to give us evidence that you comply with the GDPR. If you don't, you're not our vendor anymore. Thank you very much. This is all non-negotiable. We value our relationship with you. So these sorts of things were pretty common a couple of years ago, 2.5 years ago now, as well as, I would say, a lot of companies being absolutely flooded with documents, data protection addendums, sign this or else. So it was a pretty fraught time, and I actually think that a lot of the people that were sending those were having a bit of a panic rather than thinking things through well. In any event, we hear a lot about the GDPR applying extraterritorial, as they say. So when does the GDPR apply to a Singapore company? Okay, I'm going to use Singapore Airlines as an example because they're a good one. It applies if you've got an establishment in the EU. So I assume that Singapore Airlines will have a Singapore Airlines office in Paris, in Frankfurt, in in Spain, in a whole bunch of countries. They'll have an office in the places to which they fly, or to most of them. So that gives them an establishment in the EU. Some of the clients that I deal with here in Singapore have sales agents, have all sorts of arrangements in the EU that might be an establishment. The GDPR can also apply if you market goods or services to individuals in the EU. So again, using Singapore Airlines as an example, they've got a website that's in French. They've got a website in German. They've got a website in Spanish. They've probably got others. But there's no point in having a website in those languages unless you're trying to market your services to, or your goods and services, to French people, German people, Italian, Spanish people, or speaking people. So just because you might have a website in English and a lot of people in Europe can read English, that doesn't mean to say that you're marketing goods and services to them. We look for indications that you're actually targeting people in Europe, and language is one good indication. Another indication might be if you're quoting prices in euros rather than in Singapore dollars. And it also applies if you monitor the behaviour of individuals in the EU when that behaviour happens in the EU. So that tends to take into account your targeting and your profiling of customers. So if you're doing any of those things, you can be caught by the GDPR. The good news is, and we come back to the first of Alvin's donuts, the good news is that the requirements under the GDPR, the principles under the GDPR, which you can see here in red, map the CUDS that he spoke about. We'll have a look later at the PDPA. They pretty much map the PDPA as well. And in both cases, that's because they go back to the data processing principles from the OECD Convention of 1980. We get pummeled with contracts that are driving the data processor due diligence, or what we call data intermediary in Singapore. The vendor that you hire that is processing data on your behalf. So a very common example is when you hire somebody to do your payroll processing. Under the GDPR, the person who hires you, the controller they're called, organisation in Singapore, they're going to be responsible for what you do as a vendor. They're going to be responsible for how you handle data. They're going to be responsible for data breaches. They're responsible for a bunch of things. And they actively have to go out and do due diligence which is why you get reams and reams and reams of long questionnaires. One of the things I see that I find is a step in the right direction is the evolution of those questionnaires over time, so that we're starting to see, I would say, more standardized forms. At the beginning, everybody had their own document, and even understanding the questions was difficult, but I think that's getting much better. You've also got standard contractual clauses for transfers of data outside the EU. So they've been made available by the European Commission, and they're used a lot for sending data out of Europe and into Singapore or Malaysia or the Philippines or wherever. You might have seen a mention of the decision of the Court of Justice of the European Union just a week ago about data transfers to the US. So they've got a few problems because of the way that things are set up in the US, and because of the extent of national security surveillance in the US, issues that really come out of the revelations made by Edward Snowden back in about 2012. So anyway, you've got that structure set up under the GDPR, and that's the reason why you're getting a lot of people asking you questions. They're not trying to make your life hard, they're trying to make their life not too difficult. Here's a bit more detail of the obligations under the GDPR. When I look at what the GDPR says must be in a contract with a processor, and when I look at what the PDPC says in its guidelines on processing contracts and data sharing, the good news is there's hardly any difference. I would say the GDPR is maybe a little tougher, but not enough to make a difference. So quite commonly in the work that I do with companies, we'll just say, well, it doesn't make sense to have one version of contract for Singapore, a different one for the GDPR, a different one for Malaysia, a different one for the Philippines. How are we going to harmonise this so that one contract can be used right across the company? And it's actually not all that hard to do because of that, that same basis from which all the laws come. Under the GDPR, we have to demonstrate compliance. Under the PDPA, we have to be accountable. It's the same thing. We have to be demonstrating to controllers that we've done the underlying work and that we're keeping our programs up to date. Demonstrating accountability, that's what I was just saying. Under the GDPR, they specifically legislate, do a data protection impact assessment, have a data protection policy. Here's the role of the DPO. Keep the records of processing. I think out of that list, the only one that the PDPC doesn't specifically include in its guidelines is records of processing. Maybe not specifically, but you actually need to have them or you can't figure out what your processing is and how you can do the things that are required by the PDPA. Evelyn mentioned the APEC privacy principles. Here they are, there's 6 or 7 of them. And again, they're recognisable from what we've seen before. At collection, you've got limitations. In Singapore, we're not allowed to collect excessive data. It's the same thing. We have to provide notice in Singapore, notification of purpose, same under the APEC principles. Data has to be accurate. We saw a couple of unfortunate incidences in the last week or so of inaccurate data. In particular, a case where somebody was notified that they had COVID and several days later notified that actually that was a mistake, they did not. There's a lot of reasons why data needs to be accurate if it's going to be used. We come to security, and Alvin will talk some more about that, but you know, we hear lots about cybersecurity. We hear lots about hacking and all of these sophisticated attacks. The statistics that we see most of the time show that about 50% of data breaches are caused by untrained staff or staff that are trying to get back at you, disgruntled staff. So the operational side of things is way more important from the number of data breaches than cybersecurity is. Unfortunately, the cybersecurity breaches tend to be the really big ones in terms of numbers. We see under the APEC privacy principles a right for individuals to get access to their data and correct it. We see the same thing in the PDPA in Singapore. We see a few more consumer rights in the GDPR, but they're not that inconsistent. And of course, under APEC, we've got cross-border transfers, which I'll leave Dom to talk about a little later. APEC framework, we've seen this diagram before. In green, you can see the focuses of the APEC. They're very much focusing on preventing harm, protecting data so that as to prevent harm. Prevent the harm, for example, of identity theft. And identity theft can happen to anybody. You don't have to be rich to have your identity stolen. Choice principles, privacy management programs. The PDPC calls that a data protection management program. It's the same thing. Interoperability of privacy frameworks. Evelyn also mentioned the word interoperability. How can we implement our data protection or privacy laws so that a company with operations in several countries can work that out in a sensible way? And the APEC framework is also puts quite a heavy emphasis on public training and on communications. APEC privacy management program. You know, I get a lot of inquiries from people who say, "Oh, look, I just want the standard privacy policy." I had one as recently as yesterday afternoon where I'm saying it has to be tailored to your structure. It has to be tailored to your operations. You need to do a risk assessment and you need to figure out how to handle those risks. Whenever the PDPC starts an investigation, they send what is formally called a Section 50 notice, and that at least Alvin and I and some of our colleagues have called a love letter. And I actually said that to the Commission one day. I said, when you send a love letter, and they said, yeah, I apologise. And they said, no, we call them love letters too. One of the first things they ask for in a love letter is show us your risk assessment. Show us why this problem that happened. Show us why you didn't have, what mechanisms you had for internal oversight. Explain to us why that failed so this problem arose. Show us that you are actually accountable for what you're doing and that all of your people are trained. Show us your regular audit. Show us that you're monitoring things. It's always a mistake to just think, oh, well, I'll just find an industry that's kind of similar to mine and I'll copy their privacy policy off their website and that's all that I have to do. It isn't. You have to tailor it for your own operations. ASEAN Framework, I've got a couple of slides on this, but I'm not going to say all that much because Evelyn covered pretty much everything that we need to know. It's another regional initiative to try and make things more interoperable and to work better. The thing with the data protection law is it's actually designed to help international trade, to help the cross-border transfer of data. It's not designed to be an impediment. That's not necessarily quite true in those countries that have data localization rules. But all of these laws are about how to do something. They're not trying to stop people doing it. It's about how to do it. We come up with the principles on the right there. They're the same principles that we've seen before: consent, accuracy, security or protection, access and correction, transfers, retention, accountability. They're the same words everywhere. This is a little bit on the ASEAN framework and the digital economy. This is totally consistent with Singapore's proposals for a smart nation. It's totally consistent with what we're seeing develop. And finally, to the 9 PDPA obligations, which I hope are familiar to many of you, you see the same thing. I'm starting to sound like a broken record. Consent, notification of purpose, limitation of purpose, accuracy, again, protection, retention, access, all of the same things. So when you're looking at data protection from the perspective of more than one country, you're going to find all of the commonalities. You're going to find that you can, in most cases, implement policies and SOPs that apply right across your organisation and satisfy the legislation in each country. That maybe there'll be just a few tweaks for differences. So here's an example of a difference. For an access and correction obligation, you've got 30 days in Singapore, you've got 21 days in Malaysia. So a company might just say, okay, I'm going to adopt 21 days everywhere. And there's a lot of little things like that that you can use to harmonise your program. So my overall message is, you know, this doesn't have to be hard. It takes a bit of concentration. It takes a bit of effort at the outset to set it up, but it doesn't necessarily have to be hard. Even if it is hard, if you're, I don't know, Facebook or Google or something like that, most of us are not. And on that note, I will hand back to Alvin to do APSR.
Thank you, Lyn. Okay, so let me just take the next 12 minutes and I just peel the onion, and it really took talking about what do you do next, coming from an operational perspective, yeah? And this actually is another framework which is called the Privacy Operation Framework. In Singapore, we call the Data Protection Management Program. So there are 4 phases to it, right? And I just mapped the part here in terms of APEC framework, preventing harm, implementing the Data Protection Management Program, monitor regularly and respond to queries. You saw that as well, right? So what does each one look like? Okay, preventing harm, you need to do your data protection impact assessment, data inventory, your data flows, and your on-site audit. Right? If you don't know what that means, you know, speak to me later. But essentially, this is what we advise firms to do before you get to the next stage, which is actually looking at protecting. Protecting means you're actually developing policy and SOPs. That can only be done if you've done already a risk assessment, right? Just like a doctor will only prescribe once they've done a risk assessment on you. So there could be information security controls. I put the word tab there, can be technical, administrative, or physical. So not everything is about IT, right? And then they all flow into the data protection policy and other relevant SOPs. After you protect, what happens? You then look at how you sustain your compliance. And here you look at monitoring, auditing, and training and communications, right? Similar under the APEC framework, they look at that as well. Okay, so monitor and regularly updated. And last part, you may have incidents. Incidents can be 2 types, yeah? Can be data breach, or it can be a data subject access request. And then how do you respond? Because access request, as what Lyn said, there's a clock running on you. In Malaysia, 21 days, Singapore, 30 days. So if you don't have no processes, right, and your email is go to no reply at xyz.com, you could be in trouble, right? So these are things that, you know, again, having a privacy operation like that, which is being done on a regular basis. In my company, we regularly review this on a weekly basis with my DPO, yeah? Now let's move on to standards, perhaps in security, because some of you here may be cloud providers and all that. So what other standards exist, right? So privacy and security standards. In privacy, right, in let's say security, they are used to confidentiality, integrity, and availability. Some of you here might be IT heads and all that. But in privacy, it's notice and choice. It doesn't come under purview of the IT or info security guys. The 2 worlds meets at confidentiality, usage, and access. Let me just peel off in terms of what standards exist coming from the security world and also the privacy world outside of the APEC framework. These are ISO standards. I know it's a busy slide, but if you just look at the ISO 27000, if you can see my mouse move, you all may be used to the ISO 27000 standards, which is the InfoSec. There are these 2 very interesting extensions, Privacy Information System and PI Cloud Processors, 7017 and 018. These are new-ish, they were end of last year. And these are privacy extension to an InfoSec standard, right? Then there are other standards, of course, for privacy frameworks and all that. So again, these are additional standards you can benchmark yourself for international recognition. Okay, so I peel this onion another layer for you to see there are several frameworks you can adhere to. And I know some of you already are looking at ISO 27 extensions. Okay, now, if you look at your company, where are you in the maturity cycle in terms of privacy, right? So I think for those of you who are doing cross-border, hopefully you're already at number 3. If you have a repeatable, i.e. just got DPO but haven't got things documented, then you are a repeatable. But if you have a DPO fully documented, implemented, this is at level 3. Now at manage, where you have reviews regularly conducted and then continuous improvements, level 4 and 5 is where our trust mark looks at companies to be at. Okay, so I just break it down in 2 minutes here. So ad hoc repeatable, really, if you have nothing, we suggest you get your DPO train, right, at this level. These are typical SMEs, right? If you want to go overseas, you should be minimally at any of these levels here, right? So for us, we help companies in terms of in-house advisory. And because of today's topic of cross-border, many of you should be aspiring towards Trustmark and then CBPR or PRP certification. To do that, you really need to make sure you have already policies they are actually reviewing and have operational evidence that time-stamped to be able to demonstrate accountability, right? So we also have advisory in that area and getting companies to be certified in these areas as well, okay? So in short, there are 2 levels of competency accountability. One I just showed you was organizational. The other one is the human side, whether your guys are qualified and knowing what they're doing. And going into the region, I show you the number of frameworks and regulation. If you don't have a consistent framework to actually implement, it can be a daunting task. So we do training in that area. I just now showed you organization competency. You can benchmark to DPTM, Trustmark, or the ISOs, yeah, or right now the CBPR. So in conclusion, we run something called Data Protection Excellence Network, and we actually run a lot of webinars. It's free, so you can go join it here if you like. In fact, right now another colleague of mine is running a parallel webinar about Thailand. Okay, and good news, since I'm speaking to Singaporean firms here, right? There are 5 buckets of funding, guys, to do data protection. There is no excuse that we got no money to do data protection in Singapore. We are very blessed to have a country where the government is so pro-business. And then even if you have no resources, there's even funding for you to get a data protection officer or data protection manager. So you can't complain of no resource and no money. Right, talk to me and and I'll be happy to guide you through the roadmap for this, right? Or Dom and rest here. Okay, so yeah, I'll leave you guys with this, and I'm gonna pass over to Dom to talk about the CBPR and the DPTM. Yeah, thanks very much.